I'm occasionally asked whether there's any recourse when the legislature and governor enact a law that violates the state or federal constitutions. Now, obviously, the first action would be to challenge an enacted bill in either a state or federal court, depending on the basis for the constitutional challenge. If the other two branches of government enact an objectionable law, there's only two avenues of recourse: the third branch of government, the courts, or the ballot box. However, to make a determination of whether an enacted law uh, is or is not constitutional, there's only one avenue: the state or federal courts. And when that court determines that a legislative act conflicts with either the state or federal constitutions, then that judicial role invokes the role of the third branch of government and our system of checks and balances. So, if we assume that a state or federal court did rule that a California statute violated the California or the US Constitution, is there any recourse? In other words, can the legislature or governor somehow be held accountable for enacting an unconstitutional state law? But the answer really is no. It's not the role of the legislative or executive branches of government to determine in advance a statute's constitutionality, even if they might have been so advised by legal counsel. Rather, that role, one of interpretation, is of course reserved to our third branch of government, the judicial branch. Recall from your civics classes that the legislative branch makes the law, the executive branch enforces or applies the law, and the judicial branch interprets the law. So generally, members of the legislature and the governor enjoy a level of qualified immunity when they're acting in their official capacity rather than in their personal capacity. In addition, the courts generally presume that all statutes were validly enacted until a statute's actually declared to be unconstitutional or invalid. So this general rule is based upon a presumption of lawfulness that protects the official actions of elected officials. Note that federal law actually allows a civil private right of action for damages that may be brought against a public official who acts under an unconstitutional statute. That's Section 1983, which was enacted after the Civil War, basically to hold a state official accountable for a violation of a federal law. But these laws apply to the executive branch officials who were acting pursuant to an enacted statute. They don't apply to the elected officials who enacted the original statute. Of similar note is that judges also enjoy some limited immunity, likewise for performing their official job duties. In all of these instances, the general rule is that government officials will not incur civil liability for violating the law so long as they don't violate some clearly established law. However, in all of these instances, the court decisions deal with whether official action under a statute allows a private citizen to sue that official. For example, in a 1967 case, Pearson versus Ray, the US Supreme Court determined that officials who commit constitutional or statutory violations in good faith cases can raise the defense of qualified immunity. So there really aren't any cases dealing directly with potential civil liability for an elected official in creating an unconstitutional statute. But the legal doctrine of official immunity has existed since the common law, and that was developed by the courts. So generally, the courts in our country look to whether officials conducted themselves in good faith. Otherwise, well-intentioned public officials could somehow be held personally liable for their official acts, which we wouldn't want to occur. Now, sometimes the lawmaking process pushes the envelope on public policy issues But that doesn't mean that our elected legislative officials can or should be held liable for enacting what ultimately becomes an void or invalid statute. I think in the end, the courts serve basically as a check on legislative enactments, as do the voters ultimately in states like California with direct democracy and the power of initiative and referendum. In other words, in these 24 or so states, the citizens can challenge bills at the ballot box, and of course, in all the states and at the federal level, can file a lawsuit in state or federal courts challenging an enacted statute, and then the courts will ultimately decide whether they are consistent with the federal or state constitutions. And ultimately, the elected officials and their official actions are ultimately answerable to the state's electorate. So if the citizens believe that unconstitutional statutes are being enacted, then they can try to recall an official or group of officials in California if you have direct democracy. Or, of course, at the next ballot, they can try to vote those individuals out of office. But otherwise, there isn't any direct liability on elected officials.